All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have two arguments on our virtual calendar today, and the first case is number 19 CF 818 DAGOBERTO Machado versus United States. Whenever you're ready, counsel. And just to remind folks, when you're not speaking, might be a good idea to stay on mute to avoid any interference.
Good morning. May it please the court, Sean Day on behalf of Mr. Machado. If I could reserve 2 minutes for rebuttal. Our primary challenge here is to the expert opinion testimony of Dr. Wolf. The problematic statements of hers are set forth on page 9 of my brief in the footnote. Excuse me. The first is about the supposed machismo in Latino culture, where according to Dr. Wolf, men have higher standing than women and are allowed to do things that the woman must submit to. The second was about how Latino culture can play a part in whether a child reports abuse and delays in reporting. And in the case of this child, the child allegedly waited only a year, and according to Dr. Wolf, the typical time is 10 to 15 years, and that's for the only 25% who report it. 75%.
Mr. Day, is your argument, do you agree that this this evidence might be relevant to the delay issue with the complaining witness, and you're only complaining that it went beyond that, or do you think it's irrelevant in every way?
I argue it's relevant in every way. As to the issue of the delayed reporting, there was no delayed reporting, so one has to wonder why this was even introduced or used.
I mean, a year sounds like a delay, and just so I can, you just cited some numbers that I don't recall ever seeing. So I'm going to ask you to tell me where you're getting those from. You said that according to Dr. Wolf, and I don't think this is in her testimony, so I think you're pulling it from her dissertation maybe, that the average delay is 10 to 15 years, and that's for the 25% of people who report at all. Where's that coming from?
That is in my brief, if I can just get to that point. I believe she did testify to it in her testimony. 10 to 15 years, that was on April 1st, pages 65 to 66 is what I have. I
see. But that's not in reference to children of Latino descent, right? That is right. General reporting.
Right.
Okay.
That's the typical delay is what she testified to. And this child is alleged to have delayed only 1 year. And really, so the first incident was allegedly 2016. That was an incident in the pool where it was really just something that the child understandably did not decide at the time whether she thought it was intentional or accidental. And the later reporting in 2017 was hardly delayed at all. So here we have a typical delay of 10 to 15 years, and trying to then say, well, we need to talk about Latino culture because there was a delay of up to 1 year, doesn't make sense. It didn't need to be there. It certainly wasn't relevant. And she didn't connect it in this case at all. She did not say, okay, here's the delay and here's how her culture in this case played a part. She's really painting with a wide brush about Latino culture and about delay, which really didn't have a lot of relevance in this case. And
does the fact that she didn't connect it in any way to this case properly affect our assessment of harm?
I think it's harmful either way. It's really smearing the culture as a proxy for race, really. You know, we have the case, I think, out of the DC circuit where they talked about Jamaican drug dealers, and the court said, you know, you can't just brush this off as about country of origin. That's just as insidious as discussions about race. Here she's talking about Latino culture. There are more than 20 countries of origin that would have Latino culture. She doesn't specify what it is. She doesn't really have much expertise in the area either, other than her dissertation. She did not allege to have any expertise to testify about this.
And we don't have, I don't think we have her dissertation in the record. Does that sound right? Was it entered into the record?
I don't recall that it was. I believe it's something she testified to that she did. And
I feel like that. I think the prosecutor handed a copy of it to the defense lawyer at some point, but I just wasn't sure. You know, I mean, doesn't that seem like something? If one of your arguments is she doesn't have the expertise for this testimony, wouldn't the dissertation be relevant?
That would certainly be one piece of evidence to support her expertise. It's not a lot, just to have a dissertation talking about culture.
I don't know that it supports her expertise. I haven't seen it. It might reveal her to not know anything about the topic.
But also, as to the two issues, the two ways that this can affect the trial, the other was even worse, because the other really was about racial propensity evidence of macho Latino men just doing to women as they please. And the Supreme Court has said that appealing to racial stereotypes is especially toxic when the expert witness, you have it through an expert witness, which carries in some ways the court's imprimatur. And it's a constitutional error that implicates both fair trial and equal protection.
What do you think? Oh, go ahead, Judge Deal.
I just want to disentangle what the government says is the proper purpose from what you say is an improper purpose. Let's assume Mr. Machado is a white man, so that there's no chance that this bit of evidence about machismo in the Latino culture and women, maybe young girls, submitting and not viewing it as sexual abuse, that it could only be relevant to delayed reporting. Would you have this argument if those were the facts?
I believe that the way that Dr. Wolf connects it to delayed reporting is improper, and it is racial stereotyping. That, look, this is a culture where you have men running around wild and women are
sure. I get that, but I mean, let's say if I get your argument that it might be cultural stereotyping. If it's, but what complaint would a defendant have if it's, not of his own culture? If it's a way to explain the complainant's delayed reporting, I have a harder time seeing what argument you'd have. Is it just that there's no probative value, even if, and I know Mr. Hahn cites a Ninth Circuit case suggesting that sometimes you can get into ethnicity and culture to explain the way people act, at least if it's very counterintuitive. I think that might be right. But you think just no probative value, even if it was, even in the scenario where it could not be imputed to the defendant and it is strictly a commentary on the complainant's behavior, you still think no probative value and unduly prejudicial somehow?
No, I'm sorry. I see what you're saying now, Your Honor. Right. The issue here, the additional issue here is that the defendant and the child are of the same culture and race. And to explain why she might have delayed her reporting implicates, I think in this case, Latino men, of which Mr. Machado is a member. So that's a hypothetical. It doesn't apply to this case. And I don't know. I think it may be less prejudicial in that case, but not in this case. because it's hard to imagine why it's needed on the facts of this case where we have a 1-year delay allegedly, and there's really no delay that you need to explain beyond the norm of children delaying on average 10 to 15 years for the 25% who even reported at all.
Can you remind me what defense counsel did to sort of warn the trial court that this was coming? I mean, I remember there was a motion to preclude Dr. Wolf's testimony, and I think it highlighted Latino culture. I remember on the specific question that teed up the testimony on page 69, there was an objection and it was overruled, and the judge said, just speak generally, not about these people, only about Latino culture, I think he said. What was sort of, just to, if you could put a point on it, what point did you say, hey, judge, this is going to be a problem? You're about to let in propensity evidence that is based on race. What's the closest thing in the record that looked like that type of objection from the defense?
There was first the motion in limine, which cited the problematic issues with bringing up race and culture. They had a hearing with additional objections. And then when the evidence came in, especially when it started, it was on page 69, the testimony that was more tailored to propensity evidence, counsel objected again, and was overruled. And I would also, the Supreme Court has said the courts really need to guard against this. If you look at Buck, Buck shows how strictly the courts are tasked with guarding against race infiltrating a criminal trial. In Buck, it was the defense who called the expert, and the expert's opinion was that the defendant was not a danger. But the expert considered as one of the factors race and counted the defendant's race against him. And in Buck, there were enormous procedural hurdles because, of course, the defense brought in the evidence, and it was 20 years through a habeas proceeding that this was before the Supreme Court. And the Supreme Court found that it did, in fact, introduce extraordinary circumstances. So I think that shows how strictly the court is to guard against this type of prejudice. The defense counsel objected all along the way. And this is not a plain error issue. And this court should closely guard against this type of prejudice infecting a trial. I
guess I'm trying to understand, like there must be examples. Judge Deal's better at hypotheticals than I am, but where the evidence, though it would be troubling and would be injecting, what looks like racial bias into the trial, it still seems relevant to, maybe even to the defense maybe to a defense theory. But is it more like this is as a matter of policy? It's like in propensity evidence, like there's maybe a debate over whether it's irrelevant or relevant, but I think the better view is that it's really relevant, but we decide, we don't want to let it in absent various exceptions because, we believe in redemption. We don't want our system to allow, we're worried the jury will overvalue it or the jury will convict because they don't like the person. So, it's not necessarily a conclusion that propensity evidence is not relevant. Is that what you're talking about here? I'm having trouble, kind of getting at the core of, especially if you think this could not come in, even if really, if you had an instruction saying only tailor this to the issue of delay, you still think it wouldn't be admissible.
Certainly in this case, where you have a Latino defendant, it's hard to overcome the prejudice. And this raises both due process concerns and equal protection concerns for the defendant. Though there might be hypothetical, as Judge Deal pointed out, where really you are focusing on the complainant's delay in reporting. And there's no way that it would prejudice at least the defendant's race. That may be a different situation. That's not the situation we have here.
Help me address the question of harm. Your brief focuses on essentially one paragraph out of fairly lengthy expert testimony. As I understand it, there is no mention of this particular testimony in the closing arguments. And what we're ultimately concerned with is the impact of this statement on the jury. Why do you think that this is such a blockbuster moment that it had to have prejudiced the jury, even though it was not featured in closing argument?
I would compare it to the situation in Buck where it was in the expert's testimony, but again, that wasn't, the race wasn't specifically brought up or focused in closing arguments. This is something that, because it is a constitutional harm, it's the government's burden to establish beyond a reasonable doubt that it was harmless error. And there's no case where this.
Why is it a constitutional harm? Just simply because it's race, or we're dealing with a question of evidence here, not procedural rights like Fourth and Fifth and Sixth Amendment?
The courts have found that it implicates constitutional rights because it touches upon both due process, the right to a fair trial, and to equal protection of the law. And therefore, it's a constitutional issue. And there are no cases where race has come into a trial like this where a court has found it harmless. It's something the Supreme Court has said is an especially toxic form of prejudice that even in small doses infects a trial.
You cite very little case law, and the cases you just referred to that don't find harm. What are those that don't find harmless error?
I did not find any that found this type of error to be harmless.
Did you find any that found this type of error to be reversible besides Buck, which is the case I see you relying most on?
Buck, and I believe there are a few others cited in my brief.
I just one last question for me to press on this kind of view that a defendant's race is never relevant. Let's say that somebody was on trial for simple assault. He walked up, somebody who he had just met, he walked up and he gave her a kiss on the lips. And she said, horribly offensive, and he was arrested. And he says, you know, I'm from the Catalan region of Spain, and there kissing people on the lips as a greeting is perfectly routine, inoffensive, and I didn't even think twice about it. It's not an assault. Do you think that testimony that sort of paints a background understanding of what a defendant was thinking based on their culture, heritage, ethnicity is inadmissible?
And I'm sorry, that's a situation where the defendant is introducing the evidence?
Yeah.
Well, then I don't believe the defendant can properly object to it.
Well, that's a different question. I mean, the government objects. They say, we don't think he should get to put that in. He's playing on a racial stereotype.
I don't know that that's the same situation.
Definitely not the same situation. I'm just wondering what you think about it.
Well, and I think the concerns are for the due process rights of a criminal defendant, the equal protection rights of a criminal defendant, not necessarily of the government's rights.
But you were saying it's not relevant. Is it relevant in this situation, in the Judge Deal's hypothetical?
It perhaps could be. I don't know. I guess it depends. You have to look at the elements of assault, subjective versus objective intentions. It could play a part if it requires that the defendant intended that the touching be offensive. I don't know that it does. I think you have to intend that the conduct and not necessarily the impact. But if there are no other questions, I have nothing further.
Okay, thank you. We'll give you a couple of minutes on rebuttal and we'll hear from Mr. Hahn.
Thank you, Your Honor, and may it please the court, Brian Hahn for appellee of the United States. I think there's a couple issues here, but I'll start with whether or not Dr. Wolf was, whether or not I think that the trial court did not abuse its discretion in qualifying Dr. Wolf as an expert. Dr. Wolf, under Motorola and Daubert, there are several areas in which an expert can be qualified based on their experience, based on their training, based on their education, based on their research that they may have done. And Dr. Wolf had done all of this with regards to child victims of sexual abuse. She had worked for
if I want to know what on earth Dr. Wolf knows about Latino culture, what in the record can I look at to illuminate that? I have her CV. I can't glean much from that. What else do I have that I can look at?
So I think that the first thing is, I know we've talked about her dissertation. I know it's not in the record, but it was disclosed to defense counsel when notice was given, so a couple months before trial. And the dissertation title is Children Who Have Experienced Trauma, an examination of the role of race, ethnicity, and cultural factors in presenting symptoms and after 3 months. And
so if she wanted to testify about the habits of the Sami people in Iceland, and what does that mean? That makes her an expert on all ethnicities and cultures, because the title of it talks. I guess I'm just confused. Like, what makes you think, or why would a judge think she knows anything about Latino culture in particular?
So I think it's that, and it's the fact that she has done so much treatment and observed so much treatment of child sexual abuse victims. And so, I think that Latinos are not, I think that the Sami culture from Iceland Sami people from Iceland is a very small population, as I think that's probably why Your Honor chose that population as the example. And I don't think
I don't know what cultures she's treated. Where is that in the record as far as what victims she has come into contact with? Like, has she come into contact with kids from Honduras, from El Salvador, from Mexico? I have a hard time assessing or understanding how the trial court assessed what expertise she had to offer the opinion she offered about Latino culture, because I just don't see anything in the record about it, despite objections that she didn't have that expertise.
So again, I think that it's the fact that her dissertation was, and she says in her testimony that she does intensive research on the differences between cultures in the presentation of child sexual abuse victims. And again, the fact that Latinos are not a uncommon, race of people that are in the United States, and that she's treated over 150 to 200 children over 9 years. She didn't say how many forensic interviews that she also observed as part of her role at the Child Advocacy Center, but she said that she had seen many of them. She had performed assessments of children, comparing questionnaires of children who had suffered sexual abuse and other types of abuse with those who had not, to compare those two different populations.
Can I just ask one or two facts of what Latino culture is Mr. Machado and IA? Is there evidence about where they hail from, how long they've been in this country?
I don't remember specifically whether or not they said what country they were from. I do think that there was testimony about how long they'd been in the United States, but I cannot recall that off the top of my head.
They weren't nobody translated. Nobody needed a translator, right?
No, Mr. Machado was using a translator during the trial. I assume that it would have been obvious to the jury in that sense that he was speaking Spanish and using a translator. I don't think any of the witnesses used an interpreter to give their testimony, but there was an interpreter there.
Okay.
Mr. Hahn, I understand there's a difference between relevance and need. but it seems to me that we could rip this page out of the transcript and the government still would have made its point about why some children delay reporting. What was the purpose? What was the relevance of going into culture?
I think that this is part of what Mendambe talks about when it says the expert who testifies about a profile of child sex abuse victims isn't actually supposed to look at the facts of the case, interview the victim, and then talk about this case in particular. They're only supposed to talk about a profile of a child sex abuse victim to educate the jury on why what a child sex abuse victim might react. And
I don't think you're responding to my question. The question is, what did this add? The reference to Latino culture.
So I think the reference to Latino culture and culture in general adds that this point that there are cultural barriers to disclosure, not just, Dr. Wolf testifies about several types of barriers of disclosure, and this is just one of those types of barriers to disclosure. She talks about barriers that originate from the child, she talks about barriers that originate from the child's relationship with others, and then she talks about ones that are in sort of the societal, cultural / world milieu there. And, she's just explaining her expertise in what she sees affects why child sex abuse victims disclose. And that's what Mendambe says. It says that the expert is supposed to testify generally about how those things happen. And then
let me rephrase my question.
Sure.
Why did the prosecutor ask the question? This is better left unsaid, using a euphemism that the U.S. Attorney's Office employs often.
So I think really what happens here is that the prosecutor asks, okay, can you explain to us cultural barriers to disclosure? And she says, there are cultural barriers. These are types of barriers that there are. And the prosecutor asks, well, what's an example of one? And I mean, that happened with every other type of barrier that the prosecutor talked to Dr. Wolf about. She asked, there are child-specific barriers. What are they?
Yeah, I mean, I guess
explain what they are.
The exact question that teed all this up was, when you say different cultures differ as to what constitutes abuse, can you give us an example based on your experience? And that's at page 69. Objection. Overruled. Only speak about Latino culture. I don't see how from that question and the response that you say this is limited to a commentary on delayed disclosure. The response is very clearly, to me, a commentary on the propensity of Latino men to commit sexual abuse. It says within the Latino culture, there is a prescription of machismo, where men have a kind of higher or different standing within the culture. That may impact how sexuality is being viewed and kind of what men are allowed to do sexually and what women need to succumb to a man's demands. Like, not a peep about disclosure. This is a commentary on Latino men are more likely to sexually abuse women because they don't see it as abuse. I don't see an alternative reading of that. So if you do, I'd love to hear it.
Sure. So I think that what Dr. Wolf is explaining there, and if you read the next question and answer, the next question is, in your experience, are there particular cultures that focus more on submissiveness of females or women and girls? And what Dr. Wolf says, absolutely, yeah, there's a large number of cultures that do that. And that also very much so impacts, if a child does disclose, how others in the child's world view that and where blame is placed. I think what Dr. Wolf is the testimony there, especially in the context about how all of these are types of barriers to disclosure, is that this phenomenon of machismo, and whether or not even that it's true, but that this perception that this exists in the culture causes a barrier to disclosure from child sexual abuse victims, and of course also how other people respond to that. There are plenty of examples where a incorrect and in fact offensive stereotype guides people's actions because of their perception.
At what point does she say this stereotype is incorrect?
she does not say that.
What would lead
she's
a
not
jury
ever
to
asked.
believe? What would lead a jury to believe that this expert thinks it's incorrect?
I think it's just she's never asked whether or not it's incorrect.
What she says is within Latino culture. I mean, I don't want to read it again, but it impacts what men are allowed to do sexually.
Sure, but the question is like, what have you seen? And she has seen this perception. And the
question is, different cultures have different definitions of abuse. Give us an example. That's the question that she's answering. I mean, Mr. Hahn, I get, if your point is, look, writ large, what she's trying to talk about is disclosure, and this got sloppy. Okay, I'll maybe that's true. But I think you'd agree that if you're going to delve into a topic of a race and their propensity or disclosure or propensity to commit the act, one ought to be very careful. And the defense highlighted for the trial court, this could be a big problem. This sounds a lot like propensity. And the trial court just kind of washed its hands of it and said, oh, just speak generally, not about this case. And then when there's an objection to the question that does not speak to propensity, the expert goes off on what sounds a lot like propensity. I mean, it seems to me like it might have been careless, it might have been unintended, but it seems like a carelessness that could have been avoided and wasn't for reasons that I have a hard time really understanding. I mean, don't you think there should have been at least an instruction to the expert, don't talk about propensity, or a limiting instruction, this is only about disclosure, but nothing was done.
I think I agree, Your Honor, that, the expert's testimony could have been more precise in what she was trying to convey. I think that in the context of what she was testifying about, that the point that she was making was not, I don't think that she was trying to say that Latino men sexually abuse women more. I think she's just testifying about a cultural perception that she's seen that affects whether or not child sexual abuse victims disclose. I mean, I think I agree that she could have explained that better. I'm not sure that means that this was inadmissible testimony.
Mr. Hahn, can I ask you a question about a case that neither side has cited, but seems relevant to me, and get your thoughts on it? And I don't know whether you're familiar with Pena Rodriguez versus Colorado, which is a U.S. Supreme Court case. It's 137 Supreme Court 855, and it was handed down in 2017. And in that case, a juror, it's a child sex assault case, and it became known because a couple of jurors talked to a lawyer after the trial. A juror told fellow jurors during deliberations that he thought the defendant was guilty because, in his experience as an ex-law enforcement officer, Mexican men had a certain bravado that caused them to believe they could do whatever they want to women. It sounds quite similar to the testimony of Dr. Wolf here. Now, this case caused the Supreme Court to get rid of its no impeachment of the jurors rule and create an exception to it. I mean, not get rid of it, but just create an exception to it in situations involving evidence of racial bias. And they referred to this, saying the statements were egregious and unmistakable in their reliance on racial bias. This is a dangerous racial stereotype. So I agree. This is distinguishable, obviously, in that this is a juror who was sharing these views with the other jurors. But it seems that the Supreme Court's bottom line was, we don't want jurors to be thinking that. So how is it okay to have a witness ask them to think it?
Yeah, so I think that the main concern in both, I'm not super familiar with that case, Your Honor. I did, sort of look it up while you were talking and explaining what it was about. And well, just a little bit,
Yeah.
Now that we're on the computers, we can do that a little bit quicker. And so I think the concern in that case, when you're talking about, and also the cases that appellant cites in his case when he's talking about constitutional error, why he thinks that this is constitutional harmlessness, is that we don't want the jury to we want the jury to decide the case based on the evidence as to whether or not the defendant committed the crime beyond a reasonable doubt, and not convict the defendant just because they are of a certain race. And in the cases appellant cites, those are all prosecutorial misconduct cases where the prosecution in summation or in closing, in fact, basically argued that the person's race should be a factor in which the jury takes into consideration when deciding the verdict. And in the case that you just described, Judge Beckwith, it sounds like the juror himself or herself, I don't remember if you said it was a man or a woman, urged the jury to convict because the defendant was Hispanic. And so I think that's different than an evidentiary question of is race actually relevant to this case? It's not just because the defendant is a certain race, but because there is something relevant about that. And I think, Judge Deal's example of the Spanish person, and I forget what region that was. I'm sorry, but
I think I said the Catalan region, though I have no idea.
Region.
I have no idea if that is in fact a custom in the Catalan region. So
sure. Well, I mean, not to expand stereotypes, we'll assume that's true. I think that it, in fact, is sometimes relevant. I mean, especially, in let's say in a case that has a hate crime bias, intent or something like that, that it needs to be proven. It can be relevant to the case, and it can be probative. And the question is whether or not it's more unfairly prejudicial than probative for that particular case. And in this case, I think, let's assuming the court disagrees and with the government and says, this was erroneously admitted, it was not harmless. And again, maybe I haven't spun this out, but I do think we are looking at it under Kodiakis, this test of harmlessness and not constitutional harmlessness. But there's plenty of evidence in this case to show that the jury wasn't swayed by this error. As Judge Fisher pointed out, it was one answer to one question. It was never mentioned again by the government or the defense. It wasn't mentioned or highlighted by the government in opening statements. And there was very good evidence in this case. There was very compelling evidence. IA, the victim who testified, the trial court during sentencing, and this is the August 30th transcript at 26 to 27, said that Judge Isco said he found the victim's testimony to be completely credible and reliable. And he said he found no reason to question the jury's verdict in any way. We know that IA was, testified somewhat emotionally during trial as well, because the defense closing actually acknowledges it and tries to explain it away or talk it away. As the prosecution points out in rebuttal, the defense says IA is lying about these instances, but doesn't have any explanation as to why she might be lying about them. And then we have the evidence that comes in under battle about her reports to her aunt and her father, and evidence of her demeanor during those periods of time, both reported to the aunt Sandra by her cousin, that she's crying, that her demeanor while she's reporting the incidents to her aunt, her demeanor while she's reporting these incidents to her father, all of those sorts of things.
I guess one question I have on harm is, it seems that there are a number of cases. Pena Rodriguez is one. There's also, I don't know if you're familiar with Mejia versus United States in our court. Okay. And that's a case where the trial judge it was a bench trial. So the trial judge was the finder of fact, and the trial judge was musing about, thinking about some cultural issues I'm not really clear about. I know that in countries like El Salvador, And even in frankly, in places in the surrounding jurisdiction, there are very young girls who are married of Black descent. And I'm not clear whether or not there is, I don't know, maybe that's something council can help me with. I'm certainly not suggesting that it's cultural in general, that all people feel this way, but I've not been real clear about the issue of sexualizing young girls at a very young age or something. And my point about this is, again, it's not evidence, it's not an evidentiary issue like ours is, but it's, I don't see why it would be different if someone had presented that evidence to the judge and she had relied on it. And then, the court, reversed the conviction, granted a new trial, said an objective person could reasonably conclude the appearance of bias existed. Now that, this is a judicial misconduct case, so maybe the harm would be different, but I do sort of see a sense of courts not being all that happy about this sort of evidence and not being that inclined to think it didn't matter. It's sort of hard to analyze the effect that it might have on a juror.
And that's a fair point, Your Honor. I think that, I agree with Judge Deal that you should be very careful when you're talking about this kind of evidence. I do think that Mejia is an example of when, it wasn't admitted to evidence and my memory of the case is that it sort of comes out of left field. The judge just sort of starts talking about it at sentencing right after trial, something along those lines. And, it is something that is outside the evidence of the trial that the judge is using and musing about. And I think that there are situations such as this case where it is relevant, it's probative, and it's not unfairly prejudicial. But when someone is taking it from outside, and this is even the juror case that you were talking about from the Supreme Court, Your Honor, that this juror is taking outside prejudices that haven't been admitted into evidence or talked about or considered under the rubric of relevance, and using that to guide their decision in the case as the fact finder or even as the sentencer, and that's something that we want to avoid. I mean, I think that we generally want to avoid anyone using evidence or thoughts about the case from outside the trial inside, when they're making their decisions.
Don't we also want to avoid jurors using race as a proxy for whether or not somebody committed a criminal offense?
Yes, I think that's right, Your Honor. I just think that.
Don't you think this testimony might have invited the jury to do that? No?
I don't. I think that you and I view the testimony very differently, or somewhat differently. I think that.
That's fair. I won't drag you back.
Might the jury? I mean, the jury does. The jury gets to do its job in the case. I
guess the point is that if Judge Deal thinks that's true, and wouldn't it be a problem if one juror, even if it weren't a juror aligned with your thinking, but one juror had the same thought? Certainly, that's what happened in Pena Rodriguez.
Yeah. So in Pena Rodriguez, a juror. Yeah. Again, it's sort of the outside nature of that. I think that it wasn't an issue at all in the case, and that's why it wasn't relevant. So again, I understand that there is always. You always got to be careful when you're talking about race. I agree with that.
Can I ask one more thing that I'm find it hard to understand where lines can be drawn on this issue, but I'm not sure I'm right about this, but I think that in DC, or at least this is in my distant vague memory, that if a defendant were, say, charged with an assault involving his own child, that if he wants to, is presenting a like parental discipline defense, he wouldn't be allowed to, put on evidence saying this is what's acceptable in his culture. This is how, children are disciplined, that's not allowed. We might end right there because maybe neither you nor I knows whether that's actually true. But if it is true, how do you reconcile, that kind of evidence being excluded, and the kind in this case being allowed?
Yeah, I think I'll first say that I don't know if that's true.
Should it be?
So I'm not sure that I should, can answer a question where we assume that some law is true that isn't.
Yeah.
Should it be true? I also I can't say that I've thought about that question, Your Honor, before immediately now. I do think that you can draw distinctions between the two. I'm not sure it is profitable to go on for another, minute or so talking about those distinctions when I'd just be throwing whatever is in my head right now at you. But if there are no further questions, I think that we'd ask the court to affirm. I think that even if this testimony, this one answer to this question was improperly admitted, it was harmless.
Can I jump in? Sorry, this is
Sure,
rude,
no
but
problem.
just to ask you one question about your merger argument about counts 5 and 6. Is one question I had was the government's brief. I wasn't sure what the standard was. The government's brief says that the Blockberger test does not apply. Where I know it doesn't always apply, but I would have thought that it did apply here. Can you elaborate upon that?
Yeah, when I reread the brief, I realized actually I probably wasn't as clear as I should have been. So if you read Hannah, which is cited in the brief, this is 66 A second at 854 to 55, and particularly footnote 10. What happens is that Blockberger doesn't apply to two offenses that are based on distinct acts or transactions, or two separate incidents. And so what you first have to do, excuse me, is you look at, if there's a trial, you look at the facts adduced at trial and see, is this one incident or is it two incidents? And if it is one incident, then you apply Blockberger and say, okay, what are the elements? How does that work? And if there's two incidents, they don't merge, even if they're the same crime. And so I realized that wasn't as clear as it should have been in the brief. So, but that's my reading of how that works.
Thank you for clearing that up. And is it I guess the argument is, I'm concerned that the concern in this case is that the indictment and the instructions don't tell the jury. I mean, the instructions are the main thing. Don't tell the jury what they're deciding on those two counts. And so I know the response is that it's clear from closing argument, I guess. But why is that enough? And is that established in our case law?
Yeah, so I'd first say, I think appellant hasn't made the argument about the jury instructions. He didn't make it in his opening brief. And when the government's brief said this really is a jury instruction issue, the reply brief said, no, we're just talking about merger. And so I think that it's waived in any instance. But, looking at it, it wasn't raised below. So we're looking at it under a plain error standard. And if we're looking at whether or not it's substantially prejudiced appellants' rights, or if it is a miscarriage of justice under the fourth prong of plain error, I think that the government explaining very precisely, in fact, which incident went to which count resolves that prejudice. So in opening statement, and this is the April 1st transcript at 37, the prosecutor says count 5 is where the appellant is touching IA's thighs close to her vagina. Count 6 is him hugging the victim in her towel when she's coming out of the shower. And in closing argument, this is the April 3rd transcript of 559 to 60. She says that the misdemeanor sexual abuse of a child charge, which is the only MSA charge, is for touching her thighs close to her vagina, and that the simple assault charge, and which is there's only one simple assault charge, is hugging her in a towel as she comes out of the shower. So I don't think that anyone is laboring under some sort of misconception, the jury, the defense, the prosecution, of course, about what conduct went with what count.
And what you were just describing there, I'm sorry, is that the closing argument?
So the first one I'm talking about is the opening statement.
Right.
And then the second was closing argument.
Okay.
And so it's a through line.
Why didn't the judge grant the bill of particulars request?
Honestly, have no idea, Your Honor.
Yeah. Okay.
Appellant didn't challenge it on appeal, and I did not look carefully at whether or not at that decision. I know that it was requested and denied, and so.
Okay, thank you, and thanks for letting me take you off track there, sir.
No, that's no problem, Your Honor. That's why we're here. And again, the government urged the court affirm the convictions.
Thank you. Mr. Day, we will give you 3 minutes or so.
Thank you. Yes, Mr. Hahn mentioned cases involving prosecutorial misconduct that we're relying upon. And that's not entirely correct. And I would draw the court's attention to United States versus Doe. That's a DC Circuit case. And that's the one where the expert testified that the Jamaicans had taken over the drug trade. And the prosecutor mentioned Jamaicans having done so in closing argument. And those facts may have been correct. Who knows? But the court said, look, it's too late in the day to treat lightly the risk that racial bias may influence a jury's verdict in a criminal case. And they refused to quibble whether or not remarks about Jamaicans refers to race or something else. It doesn't matter. In legal theory, the court said distinctions based upon ancestry are as odious and suspect as those predicated on race. In practical terms, appeals to either threaten the fairness of a trial. And again, this is a case where they cannot overcome, they cannot establish constitutional harmlessness. And I didn't find any case where race affects a trial like this, or race is introduced into a trial like this, and then the court finds that it is harmless. Are there any questions by the?
Am I correct in thinking that your opening brief doesn't cite Chapman or invoke constitutional harmless error? It does. I see it. I mean, I know it comes up in your reply after the government says Kariakos. I just want to.
Right. The government is the one that brought up harmlessness, and
right.
We responded.
Fair enough. Fair enough.
And
I have nothing else if there are no other questions.
Okay. Thank you so much, Mr. Day. Thank you, Mr. Hahn, as well. And the case will be submitted. You both can sign out, leave the meeting.
Thank you.
Thank you.
Thank you, Your Honor.
And everybody here?
Yes, Your Honor. Thank you.
Mr. Jaffe, can you hear? I just want to make sure everyone.
I can. I'm just my virtual background for whatever reason has not kicked in, and I am trying to kick it in.
Okay. And Ms. Rast, I assume you can hear us?
Yes.
Okay.
Thank you, Your Honor.
The second case on this morning's calendar is number 19 CV 1246 and number 20 CV 387. Kendall Fells versus Service Employees International Union et al. Whenever you're ready, Ms. Rast.
I believe it is my turn to go.
Oh, yes, that's right. Sorry.
It's not.
Ms. Rast's position in the middle made me think that was that she was first, which makes no sense.
There we go. I managed to get my background. I apologize.
No problem.
Your Honors, and may it please the court, my name is Eric Jaffe. I represent the appellant, Kendall Fells. And I guess I'd like to start by saying there is a narrow and fairly direct path to resolving this case and remanding this case that would avoid some of the bigger questions in the case. And this case involves a variety of questions, big and small, but the simplest and most direct way is to recognize that under the basic summary judgment standards endorsed in Mann, as they should apply to a anti-SLAPP motion, this case should have gone to a jury. There is no dispute that Mr. Fells did not engage in sexual harassment, and the other side agrees and the judge agrees. There is no dispute that charge of sexual harassment would be defamation per se and that he was injured thereby. That's not up for dispute. The only dispute is whether the statements made by the Service Employees International Union, the union, in context were capable of a defamatory implication that he did engage in sexual harassment. Because if they are capable of that, it is clear that it was false, it is clear that it was harmful, and it's clear that they knew he didn't do that because they admit that they had no evidence that he did that. So
we have
yes, Your Honor.
We have some precedents. Guilford, which references back to White, a DC Circuit case.
Yes.
Which roughly says that's not quite right, what you just said. They roughly say it's not enough that they be reasonably susceptible to a defamatory meaning. There also needs to be some indication, I think from the statement itself, that the author of it endorses the inference. Something, and I think in White it was, if he had, there was some statement about a drug test, that could have been confirmed had he taken the follow-up. And that suggested they were, that it would have been confirmed had there been a follow-up. Is there something in this statement that you think, that you can point me to, that you think adds a SEIU was not only on its face that this is capable of being read to suggest that he engaged in sexual harassment, but that they tweaked it in a way that propelled that inference from it?
I think there are a couple things that could support that. From the statement itself, I think that what I view as a very conscious tying of this resignation and the related termination of Mr. Rowley, tying that back to the resignation of Mr. Courtney, Executive Vice President Courtney, who very explicitly was caused to resign because of sexual harassment and sexual relationships with subordinates. I think connecting those two events gives you that inference, at least sufficient for a jury to draw it, that they are trying to relate the two events and relate the two behaviors. And secondly, I think the word abuse, other than he was a lousy boss who didn't treat his employees well, the word abuse goes a step further. And in fact, in other instances, has been used in the context of sexual abuse. So again, if you're looking for enough evidence to go to a jury, for a jury to decide whether it's reasonable for that, I think they could rely on those two.
Wait, do you mean I'm sorry, just a quick jump in. Do you mean the word abuse has been used without the modifier sexual in other contexts to mean?
No.
Okay. You just mean
what I mean is the abuse of female employees by a male boss leads to a very natural and I think expected and foreseeable inference that it is something other than you were a lousy boss.
Understood.
And at least my point is, whether or not you think that's inevitable, I think a jury could very reasonably find that. I don't think it's beyond the purview of making that a factual question. The third piece of evidence that I think a jury could rely on was the fact that the union knew this statement, their statement, was being interpreted this way and affirmatively chose not to correct it or seek a correction. And we see that in the emails between the press person from the union and some other reporters, where they're fully aware that this is the way their statement was interpreted by very sophisticated consumers of press releases. So
what do we know about that? I mean, I saw on the record there is this email where I think it was a counsel for SEIU wrote to a reporter saying, "Oh, you're getting these facts wrong, but I'm not suggesting a retraction. But just next time, feel free to give me a call." Do we know? Was that in front? The record's kind of weird here because the trial court, a lot of stuff isn't in the record, but then the trial court permitted you some time I think, 15 minutes to go kind of put it all in the record. So there's references to things that it's not totally clear to me what document they line up with. Are those emails in the record? I mean, I know they're in the appendix. Were they before the trial court?
They were part of the proffer. My opponents make, I think, the perfectly true statement that they were not admitted into the record. But they were not admitted because the judge didn't think they were relevant, not because there was some flaw in the evidence. They were proffered as information that would be important to the decision. They were proffered as information that would justify targeted discovery into exactly what the nature of those conversations.
Sure. I mean, I take your point there. One more pointed question. Do we know, at least by November 3rd, I can't remember, maybe it's 2nd or 3rd, there's a news outlet who's expressly saying this is sexual, tied to sexual harassment or abuse. Do we know if SEIU continued to issue the same statement after that point, or do we not have record evidence of that?
I don't know that there's record evidence about the exact details. There is evidence in the proffer that they continued, that they received calls. The timing of those calls is not precise, but that they were fielding calls about this. And once again, this would be something that I think it would be perfectly reasonable in the normal summary judgment context for us to be able to inquire into, to talk to them, to potentially talk to the reporters if they're willing to talk to us about it. Obviously, there's no secret as to who their source was, so we're not getting into source secrecy questions. It's sort of interesting, right? The very fact that the press is reporting this, and we list a bunch of articles, not just the one or two, and interpret it this way, perhaps that suggests that that's how they read the statement on its face. Perhaps that suggests that they got confirmation of this when they went and said, hey, did he do the same thing that Mr. Courtney did? And there was some answer there. But the notion that the press ran with that leaves you in a weird sort of dilemma. Either the statements, both on the printed statements and any subsequent conversations, led to a reasonable inference by a sophisticated consumer of press releases that this was sexual harassment, or if those statements did not lead to that reasonable inference, the only conclusion I could come to is that the reporters all defamed Mr. Fells because they had no reasonable basis. And that strikes me as a bizarre dilemma, that you would say the reporters, having reported this, are more likely to have been unreasonable and committed defamation than the people who said wink, wink, nod, nod, we let them go for really bad behavior as a result of an investigation into sexual harassment. Right?
Mr. Jaffe.
Yes.
This is really ancient history, but once upon a time, I tried cases before juries. I would not want to go to a jury on the state of the evidence that you have described. And my question is whether in your opening brief, you have preserved a complaint that the trial court should have allowed targeted discovery before ruling on the anti-SLAPP motion. I know you talk about it in your reply brief, but I'm not sure it's fairly raised in your opening brief.
Well, I believe we did talk about wanting to know what the nature of the conversations were between CU and any reporters, but I would be happy to go and check the precise page point of that. I don't have it off the top of my head as to whether that is. But it strikes me once again that if the whole question is there sufficient evidence to conclude as a matter of law that a jury could not find that this had a defamatory implication, I think the evidence on its face that reporters did find that this had a defamatory implication should be enough to at least get.
I think one of their answers to that is, the reporters might have been relying on other things, such as the Twitterverse. And I think there was a tweet from I couldn't tell if this was in relation to Mr. Fells. It seemed to be, there was a tweet in the record somewhere of somebody saying, that's the guy who sexually harassed me.
Yeah, absolutely.
Today, CU fired the guy who sexually harassed me. And I think part of their answer is going to be, well, we put out an accurate statement and the press was drawing from other sources.
So that's a wonderful answer that they're welcome to make to a jury, but it sounds like the quintessential factual disputes. That is a question where there is a genuine dispute over issues of fact, and we get to litigate that. Because while it's not, I guess
it gets me out of the bind that you described of either this is defamatory or the news outlets were defamatory. There's a third possible answer, which is neither. Maybe somebody else was.
Yes, potentially that is true. It's not in this record, but what I can say is CU did not credit that woman's claim. And CU expressly disavows having fired him for sexual harassment. So to the extent somebody out there said, oh, this is what happened, CU doesn't believe it. The judge did take that as a basis of it. And once again, it's one of those quintessentially factual disputes where we would, in a normal jury situation, normal trial situation, be entitled to call witnesses and put them on the stand and ask them these questions. And what did you say? What did you say? And we have no opportunity to do that. So given that, I'd like to just pivot slightly to sort of say this whole question of do I get to a jury or even do I get to discovery before I get to a jury really puts in context the whole notion of the constitutional parameters of an anti-SLAPP statute. The whole point of an anti-SLAPP statute is to protect First Amendment expressive activities. It's supposed to be a shield against abusive and meritless litigation, which I don't think anybody seriously claims this is either abusive or meritless. At most, we're playing a Marquis of Queensberry's. You didn't quite get the right sentence and the right this and the right that at the right moment when we ambushed you. But nobody's suggesting that this wouldn't survive normal summary judgment and discovery. It wouldn't be dismissed on a motion to dismiss. So given that, we think there are competing First Amendment interests. There's the right to petition. There are Seventh Amendment issues, obviously, as the court well knows from Mann. There are the right to process, to bring witnesses before a jury. There are all kinds of due process rights, but I'm focusing on the right to petition question. If this is being used to shut down an attempt to petition the government for a redress of what I think is very plainly a real grievance, he was accused of something that everyone agrees he didn't do, a very real grievance that the government can in fact redress. I think you really have to apply First Amendment standards on both sides. You're trying to protect SEIU, but you're suppressing the First Amendment rights of Mr. Fells. Yes.
I hate to interrupt your flow there, but I just keep thinking about the point the union makes about you not raising the, you're basically challenging the constitutionality of the statute, and you're not, you didn't raise it in the trial court. Now, you said in your brief that how could you didn't know its unconstitutional effect on you until the judge ruled. And I mean, can you say more about that? I feel like that might often be the case. So wouldn't, I feel like I've seen arguments and in any event, if you rule against me, this is going to be unconstitutional. Was it impossible to raise in the trial court?
It was hard to anticipate given the expedited proceedings and given the existence of Mann. I think our view is the trial counsel understood that Mann was the test, was applying Mann, and in the ordinary course, if Mann applies, there's really not that much of a problem. There's good case law that this court itself relied on in Mann, pointing out why the summary judgment procedure is permissible and why it's not unconstitutional. And so in that circumstance, if you lose an ordinary summary judgment motion, I don't think it would present a petitioning problem, obviously, because you lost. You got the petition, you lost. No reasonable jury could possibly agree with you. Okay.
But doesn't your constitutional argument then kind of boil down to a non-constitutional argument that the judge applied the wrong standard or didn't follow Mann?
Well, to some extent, it is a backstop for why Mann should be taken for what it says, which is you need to apply the ordinary Rule 56 standard, even in the context of this statute. And Mann understood it and read the language a little more narrowly than perhaps was its original natural reading. It's a constitutional avoidance problem more than it is a statutory interpretation problem per se. And so, yes, it is a backstop to Mann. Our contention is that the judge didn't apply Mann. The judge shifted the burden of proof. The judge did not make all inferences in our favor, did not let it get to a jury. And I think our opponents have made very much the same argument that Rule 56 is not really the test, that it's our burden of proof. And so you're right. My constitutional arguments on Seventh Amendment are a backstop to my interpretation of Mann. If you agree with me on Mann, much of that is resolved.
Let me ask you to clarify. With respect to Judge Beckwith's question about whether you raised or should have raised a constitutional claim in the trial court, are you saying that anyone who had read Mann would understand that there were constitutional issues all over this case?
I'm saying that anyone who had read Mann would understand that not following Mann closely would raise constitutional issues, because Mann itself said exactly that. It said the reason we are going here is to avoid serious constitutional issues. So yes, that is precisely what I'm saying, that relying on Mann's standard as the right way to do things. I mean, we could say, look, if you didn't give me a jury trial, if suddenly the judge took away my jury trial, and then I have to say afterwards, that deprived me of my right to a jury trial. Well, I never would have imagined, the notion that I have to anticipate a judge going as far afield as to ignore binding precedent.
I'm sorry, could you just remind me, is your complaint about not following Mann is that the trial judge applied a likelihood of success in the merits? That sounds a lot more like a preliminary injunction type test rather than a could a reasonable jury side with you? Is that
That's part of it.
Okay, what's the rest?
Yes, the rest of it is he didn't draw the inferences in our favor. The other part is he made factual findings that were genuinely an issue. I think those are all of a piece to some extent.
Okay.
But going back to the constitutional question, the other sort of issue on that covers Seventh Amendment and some due process questions. The First Amendment question, I think, bears upon, to some degree, the scope of the anti-SLAPP statute itself and does not collapse into the Mann question. What I see here is the anti-SLAPP statute being applied at best at its very periphery in a situation that does not, in fact, further the government's interest in having passed it in the first place. And if you think First Amendment issues are on both sides, you would think of this in terms of it's not narrowly tailored as applied, right? So this wouldn't be necessarily a facial challenge. It would be an as applied challenge.
Just to bottom line your constitutional argument, which I'm a little bit confused by. If the government tomorrow, the council, wanted to abolish defamation as a cause of action in DC, would it be unconstitutional for it to do that?
If it did that for everyone, what it would functionally do is eliminate the property rights in one's good name and a chose of action. It would destroy the property right and whatever takings implications that may or may not have because of those being constitutional and common law property rights. It certainly wouldn't pose the kind of problem you're suggesting. What the real problem is when you take away what is otherwise recognized as a property right just from this subcategory of folks, you need to comply with due process, you need to have a First Amendment justification for it, particularly since the right here is not merely property, but it's the right to petition. And so if the right to petition is being suppressed in a situation that does not further the government's interest, not even in the slightest, mind you, if anything, this flips the government interest on its head. And there's no public debate here. There's no public dispute here. My client fully agrees with the broader debate that one should not harass women, one should not sexually harass women, one should not abuse women. They are not opponents in the public field. He is simply trying to defend his private interest by saying, but I didn't do that. And he's not getting the opportunity to redress that grievance. So it's not like you're serving the purpose of the anti-SLAPP statute. And I know this court has read the statute broadly as a matter of statutory interpretation, but what I'm suggesting is that there's a constitutional overlay on that requires a narrower reading, at least as applied, because otherwise it's constitutional avoidance. It's exactly what your court did in Mann by saying, if we really read it that broadly to apply in a situation like this, which hurts one part of the First Amendment badly and doesn't help the First Amendment on the other side, well, then that poses an as-applied problem under the First Amendment where the interest is not being served and the statute therefore is not narrowly tailored to serve that interest. And you would never survive First Amendment scrutiny on that, thought of in that way. So I just wanted to emphasize that Seventh Amendment and First Amendment deal with slightly different parts of the case. But like I said, the easiest way to resolve this case without having to worry about the scope of the statute, without having to worry about the Constitution, is to recognize that there is enough evidence here that a reasonable jury could agree with us. They might not, they might agree with my opponents, but they certainly could agree with us. And I think we should have gotten to that jury and at a minimum gotten to proceed in the ordinary course of litigation to deposing people, to putting them on the witness stand, whatever it takes.
Okay.
I'm sorry. The last thing I'd say is just relating to attorneys' fees. The magnitude, I mean, we make all of our arguments in attorneys' fees. You can see them in our brief, and we agree with them still, obviously. But I would just say that the magnitude of the fees in this instance sort of highlight the deterrence of speech, the deterrence of First Amendment activity. $100,000 against an individual by a giant union with resources far in excess of his. That is the penalty for having the audacity to try to defend yourself. And I think that emphasizes the First Amendment concern from the other direction in this case, is that there's really a massive penalty being applied in a situation that this statute really wasn't built for.
Okay, thank you, Mr. Jaffe. We will hear from your opponents. Ms. Rast, we did receive your notice, and thank you for filing that. Let me know if I'm understanding it correctly, that you're going to start. You're going to split the time with Ms. Keller, and you're going to start with 5 minutes.
Your Honor, since filing the notice, we've just decided to flip the order, if that's all right with this.
Oh, okay. Okay, that's fine. Thank you for your notice.
Of course, thank you.
Ms. Keller, whenever you're ready.
Good morning. May it please the court. I want to dive right in here in response to Mr. Jaffe's arguments, because I think there's a few areas where he's got it not quite right. First, on the standard here under Mann, it's very clear under the statute that the plaintiff here bears the burden of coming forward with evidence. The statute itself says the responding party must demonstrate that the claim is likely to succeed on the merits. In this court, in the Mann case, said that it's essentially a reversal of the allocation of burden under the summary judgment standard. So as typically in a summary judgment case, you have the moving party that has the initial burden of coming forward with sufficient evidence to show that this shouldn't go to a jury. Here you have the non-moving party whose burden it is to present sufficient evidence to show that a jury could find for them, a jury properly instructed on the law, including any applicable heightened fault and proof requirements, could find for the claimant on the evidence presented. So it gets back to Judge Fisher's question about with what the plaintiff put in front of Judge Pan below, is that enough for a jury to find for them on their defamation claim? We think the answer is clearly no. And there's sort of a mishmash of things that was presented. And at the time, they didn't even have copies for opposing counsel or the court, but the court allowed them to put in a proffer of a few things. It all basically.
Can we just start with the November 2nd statement?
Yes, absolutely.
Why wouldn't the November 2nd statement, if read with an understanding about what happened on October 23rd in the ongoing internal investigation, be susceptible to a reasonable interpretation that a juror might draw that it's suggesting he engaged in sexual harassment? And I want to point to a couple aspects of it that I think are interesting. One is, why refer back to the ongoing internal investigation when that seems to conjure up references back to Mr. Courtney? And why say predominantly female staff, if not sexual harassment, if sex has nothing to do with it? So let me start with those two questions.
Thank you, Your Honor. First, I'd note that it's mainly the press that draws the connection to the Courtney resignation.
Well, I mean, the statement says through our ongoing internal investigation, which is what 10 days earlier after Courtney was fired, I thought it was, this is prompting an internal investigation.
That's correct, Your Honor.
Okay. So I mean, it's in there. It's in the statement.
It is. And I'd like to refer back to the precise statement, which says, as a result of information that has come to light through our ongoing internal investigation, today SEIU took action on 2 senior staff. These personnel actions are the culmination of this stage of the investigation, which brought to light the serious problems related to abusive behavior towards staff, predominantly female staff. So the words abusive behavior towards staff, predominantly female staff, nowhere in there does it say sexual. Nowhere in there does it say
that is the nature of implied defamation, counsel. Is there literally true statements when juxtaposed might give rise to a reasonable inference of what it means? And my question stands: why say predominantly female staff at all? Like if this statement said predominantly handicapped, abuse related to abusive behavior toward predominantly handicapped staff, you think that would be susceptible to an inference that it was discriminatory against handicapped people in some way, that the abusive behavior? I think so. And I think when you say predominantly female staff, you're kind of nudging along a similar inference.
I agree that it nudges along an inference that the abusive conduct that Mr. Fels engaged in was visited particularly or predominantly on female employees.
No, it
That,
says
however,
that. It doesn't nudge along that inference. It says that explicitly. What I'm saying is it nudges along an inference that it was tied, that the abusive behavior itself was related to their gender.
which is very, very different than an implication that the abusive behavior was sexual in nature. You can have abusive behavior that is visited particularly upon female employees that has absolutely nothing to do with sex.
That is visited because they are female employees, that has nothing to do with sex. So, I mean, I agree with that statement. I'm just not sure that that's what comes to mind when most people read this. In the light of the Me Too movement, within 10 days of firing somebody for a sexual relationship, referring back to that investigation, and then saying that they're predominantly female, don't you think a jury should have some say in how a reasonable person would interpret that? And doesn't the fact that media outlets are interpreting that to mean sexual harassment lend some support to the view that a reasonable jury might think so too?
I think there's 3 responses to that, if I can get through all of them. The first is I'd like to point you to what SEIU said about that investigation, which is quoted in the BuzzFeed article at Appendix 190. So the BuzzFeed article references the October suspension of Mr. Courtney. And it says, at the time, the union launched an investigation to, quote, look into questions about, and then there's 4 things that they say that they're going to be looking into. 1, potential violations of our union's anti-nepotism policy. 2, efforts to evade our code of ethics. 3, subsequent complaints related to sexual misconduct. And 4, abusive behavior towards union staff. Then almost 2 weeks later, Mr. Fels resigns. And at that point, the union says, he resigned due to abusive behavior towards staff, predominantly female staff. So if you're reading those 2 together, which is, I think,
your brief says those 2 things are distinct, but they're not. Do you agree that sexual misconduct might also be abusive behavior?
That's correct.
Okay.
But that doesn't mean that abusive behavior is sexual misconduct.
Yeah, I mean, it seems like you might want to say that it's not sexual misconduct, though, when they tend to go hand in hand.
Well, I don't agree that abusive behavior towards staff in any way implies that it's necessarily sexual. That would be like saying someone has engaged in an ethics violation at the office, that necessarily means that they were embezzling. There's lots of different ways.
No, but if you referred back to an investigation into embezzling, and then you said with regard to managing of funds, you might start drawing that inference. And that's what this statement looks like. It's not just saying abusive conduct, it's saying abusive conduct in relation to this investigation that is relevant to Mr. Courtney, who engaged in sexual misconduct, predominantly of female staff. I mean, you might be right. Maybe it's an unreasonable inference, but don't you think a jury might think otherwise? Don't you think a jury could say that and say, a reasonable person probably thinks this refers to sexual harassment? No? You think that's crazy town?
I wouldn't say crazy town, to your honor, but I would disagree with the premise. The Guilford case has been very clear that the question is one of law. Whether the statement is fairly susceptible of the defamatory meaning is a question of law for the court, not one for the jury. And in that same case, the court said, to hold the defendant responsible for every inference a reader might reasonably draw would undermine the uninhibited discussion of matters of public interest. The First Amendment, this court has said, I think repeatedly, that the First Amendment provides a sanctuary for the truth. And when you have a literally true statement, which is what we have here, and that's, I think, a challenge, if you have a literally true statement, then the First Amendment provides a wide berth of protection for that. And this court has said that over and over again, and has described the standard for defamation by implication as a rigorous standard. So there's essentially 3 things he has to meet to even, make a showing to get to the jury on a defamation by implication. 1 is that the statement was fairly susceptible of such a meaning. 2, the statement must contain additional affirmative evidence suggesting that the defendant intends or endorses the defamatory inference. There's none of that here. And 3, because Mr. Fells is a public figure, he also has to meet the malice standard. On top of that, rigorous standard set forth.
I thought in a footnote in your brief, you made clear that the trial court didn't reach that question.
The trial court
wasn't relying on state of mind evidence, and so I mean it would be a little bit odd for us to get into that in the first instance, if that's right.
Well, the trial court didn't reach the malice because she said it wasn't necessary, because she found that he hadn't met those first 2 prongs, that showing that the statement was fairly susceptible of such a meaning, and that there was additional affirmative evidence suggesting that the defendant intended or endorsed the defamatory inference. So she didn't even have to get to the malice standard. But, obviously, if this court had some issue with the first 2 prongs, it would be necessary to reach the malice standard, which, again, it's a question of law. So it's properly before this court.
Why does a failure to retract or clarify after the media outlets attribute this to sexual harassment properly factor into an evaluation of whether or not this was reckless or malicious?
No, absolutely not. And this wasn't really raised in the brief, so we
You don't think that's evidence of intent, recklessness, or maliciousness?
And after the fact,
yeah.
And after the fact, failure to retract. No, there's no case law saying that a failure to retract.
Let me give you an example. Let's say I hit somebody with my car, and they're on the ground writhing around, and I get out and I look at them and I get back in my car and drive away. You think that's some evidence that I hit them on purpose versus on accident, as opposed to if I had stopped and helped them? I mean, that seems like evidence to me that it's malicious. It seems like evidence to me, if I'm not going to do anything to make it better, that I intended it. You don't think it's evidence of that?
Respectfully, this is a very different context. And the practicality is that if you issue a retraction 2 days, 3 days later that says, we want to be clear, Mr. Feld engaged in abusive conduct towards staff, including a lot of female staff, predominantly female staff, but he didn't touch them in a sexual manner. We just want to make sure everybody's clear on that he didn't touch them in a sexual manner. All that does is give
or
air
sexually
to the
harass
story.
them in any way.
And then the story is repeated over and over again. There's a lot of reasons why speakers don't engage in that sort of, the other thing I'd point your honor to is third-party speakers are going to have their own biases. They have their own interests at stake here. And when this case started out, Mr. Fells was relying particularly on a piece that was published on the Breitbart website. And if you look at that Breitbart article is in the record as well. It's at Appendix 192. If you look at that article, that's the one that is primarily, it's the most wrong. Its headline says 4 SEIU officials out of a job because of sexual misconduct charges. If you actually read the Breitbart posting, there is nothing at all, not a scrap of anything in that article that says anything about sexual misconduct. They just smacked a incorrect title in order to get your statement. I'm sorry?
Did they quote your statement?
They actually quoted BuzzFeed's quote of the statement. So it's clear that they were relying on the BuzzFeed article in order to get their coverage. And they do quote the portion of the statement that says abusive behavior towards staff, predominantly female staff. If you read that Breitbart article, it's very clear that they have no source that's saying sexual misconduct.
I mean, unless they read that statement to say that, and they think readers will read it likewise.
And an outlet like Breitbart clearly has its own interest in both driving a certain kind of traffic towards its site and potentially in portraying information in a certain way. I mean, the other thing I would like to point out, I think one of your honors mentioned this already, but it's clear from the face of the BuzzFeed article that they had other sources. So the BuzzFeed article references that they were speaking with more than a dozen former and current staffers who had complaints about abusive behavior by organizers. And so it's very clear, and then that in combination with that tweet that Your Honor referenced earlier, that refers to Mr. Fells as someone who had sexually harassed her and fired her.
Counsel, I'd like to take you back to the subject of retraction. Do you agree that SEIU has no evidence that Mr. Fells was guilty of sexual harassment or sexual misconduct?
We have stipulated throughout that it was not sexual misconduct. Whether it was gender-based harassment to treat women in a particular way.
I got that. Do you think it would be unfair in any way if you won't issue a retraction? Would it be unfair for this court to say in a published opinion, no matter who wins the case, to say in a published opinion what you just said? It was not based on sexual misconduct.
That would not be unfair, Your Honor.
Thank you.
I had a few more points to respond to, but I also see my clock is up, so I don't want to overstay my welcome if the court would prefer to move on to Ms. Rast.
Do your best to hit them quickly.
Okay, all right. I did want to respond to 2 points that the opposing counsel made, and one being that he feels that this isn't within the heartland of what the anti-SLAPP statute is intended to protect. And I take issue with that in two respects. And one is this court heard a very similar complaint in the Burke versus Doe case, Doe versus Burke case, and rejected it, saying that there's no such thing as a classic SLAPP. The statute refers to any suit that meets the definition set forth in the statute should be dismissed. And we certainly meet that here. On a larger point, I disagree with his assertion that there is not a public interest in this sort of debate. Certainly over the last few years, we have, as a country, grappled with how to discuss workplace misconduct and whether that's an appropriate topic for conversation at all in the public sphere. And I think we recognize the importance of being able to discuss these issues in the public sphere, have a robust debate about the conditions that workers, including female workers, but including all workers, face in the workplace, and what employers do when confronted with those issues. And if you look at the totality of SEIU's statement, it's clear that SEIU was engaging substantively on those issues by saying that they were looking to create an open space for dialogue about those conditions and looking to allow workers to bring forward those issues, which is just such an important part of the public debate and protecting the community well-being here. Just quickly on the fees issue, the plaintiff below did not object to either the number of hours we submitted or the use of the LAFI rates for the reimbursement. If you look at it was clearly all set forth in a declaration to the Superior Court, and she was well within her discretion in granting it. There was no specific issue with any of the particular hours, and the hours did cover the fees petition as well as the anti-SLAPP motion and the reply and what was a very lengthy hearing before Judge Pan. And I would note, this court said in the Doe case that the plaintiff could have avoided the fees by dismissing at any time. Here, that argument has even more weight because this plaintiff had two bites at this apple. He filed in Michigan, which was not.
That's an interest. I know where you're going, counsel, so I just want to interrupt for a second. But the Michigan court found that it survived a 12b6 motion to dismiss, right?
No, Your Honor. That's a different case.
That's Raleigh. Am I thinking of Raleigh?
That was the Raleigh case.
Okay. And Raleigh actually has since survived a motion for summary judgment on defamation as well, right?
Not on those issues, actually not on any of the written statements. The court granted summary judgment for SEIU on all of the written statements. There was a fact dispute found with respect to one oral statement, and that very narrow piece survived summary judgment, but all of the written statements. And
just to make sure I understand correctly, because I think you've corrected a misunderstanding I had. I had thought before dismissing for forum nonconvenience, the trial in Michigan, they found that they survived 12b6, but that's wrong.
That is not correct, Your Honor.
Okay.
The court did allow, the court before hearing the motion to dismiss for foreign nonconvenience ordered that discovery should go forward. So we had responded to their request for production with a substantial paper discovery production. And even after getting all of that paper, which was essentially all the communications, internal and external, about the public statements that would be made, he filed essentially the exact same complaint here in the District of Columbia. He still just didn't have anything and decided.
There is, I will say, there is a fair bit, in the limited stuff that we have. There does seem to be a habit of saying, let's have a phone call about it. By the way, this is off the record. Let's do a phone call, which might seem like grounds to suggest that whatever is in the paper discovery is that there's more out there, and there's reason to think there's more out there in terms of what those conversations were.
Well, I could respond on that if Your Honor would like, but I don't.
I mean, there's okay. If you'd like to, I know it's not a question. I just thought it was interesting that sometimes those email threads ended with "Let's have a call about it."
Yeah, the general counsel email that you'd referenced, which did end with "Let's have a call about it." I think that was more about the general relationship. Let's have a call about the fact that you can call us anytime if you have questions. That was a email between counsel at SEIU and a professor at Harvard, actually. It was not in reference to any sort of press statement.
Well, it wasn't. It was in reference to his blog post referring to it as sexual harassment, and then the follow-up was, "That's not actually how it happened." And then he says, "Well, look, Bloomberg said it too." And then the response was, "Well, don't just run with what Bloomberg says. Talk to us." And then he says, "Let's have a call about it." I mean, it's kind of in reference to his statement.
Yeah, and there's certainly no evidence that after that email there was an additional blog post from On Labor. It was a conversation about the relationship and fact checking and things like that. I think more than any sort of conversation that was going to go towards a future statement that might give Mr. Fels some sort of claim that he hasn't made here. Based upon the evidence that he made as the proffer, there clearly is not enough to get to a jury on straight up defamation or defamation by implication that he engaged in sexual misconduct. And with that, I'll rest and turn it over to Ms. Rast unless you have further questions.
Thank you. Ms. Rast. Ms. Rast, we'll hear from you on behalf of the district.
Good morning, Your Honors, and may it please the court. Picking up to begin on Your Honor's exchange with Mr. Jaffe, I'd like to start with a short note about the nature of the constitutional challenge at issue here. So, appellant has in his response brief disclaimed any facial constitutional challenge to the act. And as such, this court can, as mentioned, resolve the case without addressing the act's propriety under the First or the Seventh Amendment or the more sweeping questions about the act's interpretation in light of these constitutional questions. As Judge Beckwith noted, to the extent that the issue is, for example, whether the lower court weighed evidence or made a credibility determination, then what the plaintiff framed as an as-applied constitutional challenge is at bottom a question about whether the Superior Court properly applied the act as it had been interpreted in Mann to bar these kind of credibility determinations. That question can, of course, be resolved on the merits, and the district is not taking any particular position on it. However, to the extent that this court would like to consider the constitutionality of the act more generally or the application of the act's discovery provisions, I'd like to address a few brief points. So, as mentioned, the Seventh Amendment challenge here is resolved in Mann. The Mann court construed the likelihood of success prong as a test of legal sufficiency so as to preserve plaintiff's right to a jury trial while allowing for early dismissal of legally insufficient claims. Second, there's no constitutional right to discovery more extensive than that provided by the Act's targeted discovery provision. So the Anti-SLAPP Act preserves the ability of plaintiffs to get targeted discovery as long as they can show that discovery will first likely help them defeat the special motion to dismiss, and second, that it will not be unduly burdensome. This court noted in Herndon, for example, that parties to civil judicial proceedings are generally not entitled to pretrial constitutional discovery as a matter of constitutional right. And much less has this court suggested that there is a constitutional entitlement to automatic discovery or to discovery more expansive than that provided by this act. In fact, in Mann, the court recognized that the Act's limited discovery provision is an integral part of the anti-SLAPP regime, and it allows the court to efficiently identify and dismiss legally insufficient claims without burdening the defendants with expensive litigation procedures. We also think that the access to courts issue raised by appellants here was forfeited through failure to develop the argument on appeal, but I'll just note briefly that this court and the United States Supreme Court have repeatedly recognized that the right of access to courts protects only the filing of meritorious claims. To the extent your honors would like to address this question, we encourage the court to follow the California Supreme Court and Equilon Enterprises, for example, which recognize that the Act's test for legal sufficiency preserves the right of access to courts as established by the United States Supreme Court. And lastly,
can you just repeat this statement? The right of access to courts extends only to meritorious claims?
Yes, that's correct, Your Honor.
What does that mean?
So
if let's just say, the court just doesn't even accept a filing from somebody. Well, first, I'm wondering what the citation is for that, and I'm sure you'll give it to me in a second. And then assume a court just says, we're not accepting this filing. And then on appeal, the opponent, let's assume it goes up on appeal somehow, despite the lack of a filing, it's mandamus or something like that. And the other side says, don't worry about it. This thing was going to lose anyway. That's no right of access claim, no cognizable right of access claim that you've been kind of not allowed to proceed in court at all?
So, Your Honor, in Bill Johnson's restaurants, for example, the United States Supreme Court said that in the first instance, suits that lack a reasonable basis are not within the scope of First Amendment protection. So in that case, the court said that if a suit truly had no reasonable basis, the NLRB could enjoin.
Okay, that's a little different than meritorious to me, but
yes, that's correct. And I think that it addresses, and most of the United States Supreme Court cases on this issue address in the first instance the filing of the lawsuit. But the question becomes sort of as the lawsuit proceeds, at what point can a court dismiss it? And at what point does the First Amendment right of access to courts continue to protect the ability to pursue a lawsuit after filing? So the California Supreme Court in Equilon Enterprises, for example, said that the right of access to courts does not protect the ability to pursue a legally insufficient claim. So at the point, and I think this court would likely agree that summary judgment, for example, dismisses a legally insufficient claim before proceeding to trial. And similarly here, if the test is read as in Mann as a test of legal sufficiency, then the right of access to courts does not extend to that claim. If there are no further questions, then we would just ask this court to reject appellant's constitutional challenge to the Anti-SLAPP Act.
Thank you, Ms. Rast. And Mr. Jaffe, we will give you 3 minutes for rebuttal.
Thank you, Your Honor. A couple quick things. First, regarding the standard for defamation by implication, my opponent suggests that it's a legal question. I would say that the legal question is whether it is capable of, i.e., whether a reasonable jury could find that, not whether they should or would find that. And then in that sense, it's the same as the summary judgment question. It is not an independent legal question any more than the no reasonable jury could ever find that kind of legal question, which of course a judge decides. Second of all, I want to go back to a question that Judge Fisher asked about whether we preserve the discovery objection. And the answer to that would be on page 13, we mentioned the need for the prospect of further discovery. And on pages 40 to 42 in our opening brief, we mentioned the due process need for discovery and why, even though discovery per se is not a right, it is a substitute in the summary judgment context. Because of course we would have a right to call witnesses, just a basic due process right, we'd have a right to have process to bring witnesses to trial. So when you're circumventing the trial, I believe that discovery is a right. It's not an intrinsic right, but it's a derivative right that stops this from being a violation of a jury trial right and the right to call witnesses. So I think it is a right in this particular context, even if not in every context. The next thing I would suggest is that there was a discussion of the Breitbart article and whether it had the sufficient details. I would just point out that on pages 4 to 5 in the footnotes there, you will see dozens of articles that draw exactly the same conclusion we're talking about, and that should be sufficient. Whether those articles also relied on statements made by other people, again, I think that just proves why this is a factual issue and there are genuine disputes that are worthy of going to a jury, or at least to a more full-blown summary judgment proceeding with discoveries and what have you. That's the same thing would be true of the suggestion that these discussions with journalists or with the law professors were trivial. The law professor was only one of several. There is no dispute that journalists called up SEIU after this press release and was asking questions about it. And we know that that's in some of the other emails, that they're fielding calls. We would be entitled to discovery on that. As for the burdens, who has the burden and whether or not this is in the heartland, I think my opponent misses a point. The literal text, if we were all textualists and going with the literal text of the statute, we'd probably just strike it down because it's plainly overbroad. But what this court did in Mann was say, we're going to read kind of ambiguous texts far narrowly, because if we don't, it raises constitutional problems. That was true with the burden of proof and the summary judgment standard, which quite frankly doesn't easily fit with the language of the statute. And it's also true, by the way, with the question of what is and isn't in the heartland. I know what the statute says. I'm suggesting that as applied and as a matter of avoidance, one needs to read that narrowly, not because it's not within the potential words of the statute, but that if the statute actually meant that wildly overbroad coverage, it would be unconstitutional. As for the fees, we plainly objected that they were excessive, given how little they had to do to raise an argument they'd raised before. And as to whether this is a public issue, I would say no more so than that would be true with every employee's firing is a public issue, and this court has already.
But most employers aren't called by multiple news outlets when an employee is fired, right?
That's true, but again,
do we think that's some evidence of whether or not it's a public interest? Constant, like a seeming stream of contacts from media might do the job.
Well, I remember they issued the press release, so I'm not sure.
I don't think that's true. My understanding is that they had a statement that they prepared when press called them, and that statement was not released. If you think it was released, you show me where. But my understanding is that media contacted them, and when they did, they would respond with this press with this
that
statement.
May be. Okay. I'm not entirely confident of the answer to that, so I don't want to make a representation. My understanding that the email went out, but perhaps the order is in reverse. I will say though that the test for whether you're a limited purpose public figure is whether you thrust yourself into the public eye, not whether somebody else thrusted you into the public eye. And so that's a little unfair. Mr. Fells made no statement about this. Mr. Fells did not have this fight with the press. He had this fight privately with his employer and said, please retract this. I didn't do this. So again, he wouldn't be a limited public figure for that purpose. And the notion of public interest because you generated the public interest seems a little bit like driving an elephant through a mouse hole. It just lets them get away with whatever they want. As for the other case, I would say that in the other case, what they found was that in context and given other conversations that surrounded the statements about Mr. Raleigh, and remember, Mr. Raleigh and Mr. Fells are sort of on parallel tracks, and the public press statement applies to both of them. They found it survived a 12B6 motion. They found discovery was appropriate. And even if at the end of the day, they didn't think some of the statements were enough for Mr. Raleigh, I think we have articles that come out that are talking about Mr. Fells specifically and not Mr. Raleigh that suggest sexual harassment. And so that at least differentiates them. But more importantly, they saw that there was testimony about internal conversations and how people within the union were being told about this, which could very easily be the basis for why other reporters had different information. Because they told the internal people leaked it to the press, and lo and behold, there you have it. And once again,
if I remember right, Mr. Raleigh survived summary judgment primarily on Mr. Fells' deposition testimony about what he was privy to, which might be subject to more scrutiny in Mr. Fells' own case as being self-interested.
Well, absolutely. I don't have any questions that credibility determinations, detailed depositions, and cross-examination are fully appropriate in this case. No one has suggested otherwise. My only suggestion is that if all of this back and forth and didn't they doesn't raise enough of an issue to go to a jury about what actually happened, or at least go to a full-blown Rule 56 motion rather than this truncated gotcha kind of motion, I don't know what does. This is not absent the slap.
I have a question about that wasn't in the brief, and I don't recall what the answer is. Is there, after if a anti-slap motion is defeated by showing a likelihood of success, and by that I mean sort of what man says on summary judgment that a reasonable jury could find, and then you get discovery. There is another, I assume, although I can't recall if we've said this clearly, I assume there is then another more full-blown summary judgment motion.
I would assume that that's correct, though I don't recall any specific case that says that. But given the fact that slap motion,
or discovery will come out, things could evolve that you would think be
absolutely
subject to another round. And I just wasn't sure if we've said that or if that's all right.
Yes, you could imagine that the court says at this time on this record, this is not sufficient that I could conclude that you have no prospects of surviving summary judgment. We're going to have discovery, we're going to have depositions, and we'll see where it goes. And then you can renew your motion and make it a summary judgment motion rather than a slap motion.
But you're not familiar with the case that makes that clear, though.
I am not, but we would certainly not say that that's inappropriate, given the very point of due process for both sides, not just for us. Everyone gets to make their record and make their motions. If there are no further questions from the courts, I would suggest that the simple and clean way is to say there was enough here to proceed with litigation, and that to hold otherwise would raise troubling concerns that the court need not get into because we would let it proceed. If you feel like that you need to say more, I would say that there are constitutional rights on both sides of this equation, that the anti-slap statute does not simply protect the speaker who defames somebody, but it also protects the person seeking redress of grievances and should not be used as a sword rather than a shield. Thank you, Your Honors.
Thank you, Mr. Jaffe. Thank you also, Ms. Keller and Ms. Rast, for your briefing and your arguments today. We will take the case under advisement. And for today, the court is adjourned.
Thank you, Your Honor.
This court is now adjourned.